Do you know how much it costs to litigate a case like that? You're talking 6-7 figures. Nobody's going to do that. You're not going to do that, right? This is how much litigation costs in America. There is no justice in our justice system. Maybe that should be the first lesson you have to understand as a small business owner.
I'm so excited today because we're joined by one of the most trusted legal voices in the entire Amazon e-commerce world, and that is Paul Rafelson. Paul is the founder of Rafelson Law Firm and the creator of Seller Basics. It's a legal service built specifically to help Amazon sellers stay protected and stay in business. He's known for running Earth's most seller-centric law firm. Basically being the voice for all of us sellers. Paul has guided countless sellers through trademarks, IP issues, suspensions, mergers and acquisitions, and all the legal traps that pop us you scale your online brand. And here's why you need to watch this episode. Most sellers don't realize, they're only one mistake away from losing their Amazon account, their brand name, or even getting hit with an IP complaint that could wipe out their entire business. And it's really scary. So Paul is going to break down exactly what beginners must know before they list their products, source inventory, or build a brand. And this episode is brought to you by Profit Cyclops, and it could literally save you thousands of dollars and months of stress by helping you avoid the most common legal mistakes that new sellers make. So if you're ready, I'm ready. Let's get into it. Yeah. All right, Paul. Just gonna start to help the viewer here understand the basics because, having all these legal terms and stuff can get very detailed and technical and can scare a lot of people and sellers. So the goal of, kind of this podcast is just to make it very digestible so sellers can feel educated and get a tons of value after watching this. So if you don't mind just kind of introducing yourself, your background, and, how'd you get into this Amazon space?
Sure. Well, thanks so much for having me on and inviting me to talk about this stuff. I really do enjoy the subject matter of, e-commerce and how it cross paths with intellectual property, such an important, area of running an e-commerce company. Like we tell our clients who sell their businesses, the ones who own their brands, when you go through the valuation table and you're saying, okay, what's the most valuable asset you're selling? It's the trademark and goodwill. So, IP is very, very important here when you run an e-commerce brand, especially. So a little bit about me. I've been a lawyer for scarily 20 years, a little over 20 years now. I spent most of my career as a corporate attorney. I worked for companies like Microsoft, Walmart, GE. Oh, wow. After I left GE, they were sort of moving their headquarters to Boston, and I didn't want to go. I was invited to write a blog post about, believe it or not, sales tax, and all the Amazon sellers were being attacked for sales tax issues. And I knew a thing or two about the constitutional law of sales tax, and just started, wrote a blog post, and it snowballed into a law firm. It just came to this realization after writing the blog post and the response that I got that there's a lot of people out there who need a lot of help from lawyers who have international commerce backgrounds, and there really aren't any. There was lawyers with my background typically don't serve small businesses. So I saw it as sort of this opportunity to sort of scale, what was scalable, or find the economies of scale, I should say, in the Amazon business model. And so that we could really create a law practice that was fine-tuned to Amazon sellers. A little further background about me. I was an Amazon seller 20 plus years ago. I was a reseller. I was actually more than Amazon. I was half.com, eBay, Craigslist, you name it, what platform I was on it, flipping DVDs and video games back in the early 2000s while I was kind of paying for law school. So that was kind of me. When I was at Microsoft, there's a lot of coincidences that led up to this. I find funny in my life. My wife worked for Seller Performance, the team that everybody loves to hate. At Amazon. It wasn't called Seller Performance back then until towards the end, but so I used to hang out with those guys. I used to hang out with all the Seller Performance team, because those guys are kind of more our age than my Microsoft colleagues, so we tended to hang out with the Amazon people more than the Microsoft folks. So yeah, I'd be having dinner with the entire appeals.
This is in Seattle?
Yeah, when I lived in Seattle at Microsoft in Redmond. I lived in Redmond, but my wife worked in Seattle, and Yeah. So it was kind of like weird, like all these little coincidences of my experience and background understanding of Amazon. I was still a part-time seller, even through GE. I have a basement full of crap that I had was going to sell. And then this all came up. And I'm like, all of a sudden I don't have the free time that I used to have.
Yeah.
Working a corporate law job is typically pretty cushy. It's pretty much a straight 9 to 5, 5 days a week. So I had a lot of free time to go and be a reseller part time. And that was kind of my plan. And then this happened and things changed. So yeah, a lot of different life experiences kind of led me down this road. And it's been a lot of fun. We've been, Amazon e-commerce centric law firm. This has been going on for just over 8 years. It's hard to believe. It feels like just yesterday I started this thing, but it's been 8 years. And we've done so much and learned so much along the way and had so much fun helping sellers and, love to share what we know.
Yeah, and that's amazing. As I mentioned earlier, I use you guys as service with Seller Basics, and it's so cool to see that you've walked the walk, right? Like you're known for Earth's most seller-centric law firm, but like it's true. You kind of know like what's like being a seller and like what the struggles is and stuff like that. So yeah, I kind of just want to go over like what would be like one simple piece of legal advice you wish every Amazon beginner knew in day one.
Absolutely. So it depends on the path you're going down. I think from a reseller standpoint, we can start there. Just understanding a couple things. One, a lot of people, so Seller Basics is it's not a law firm. It's a company we set up that's sort of adjacent to our law firm. It focuses on appeals and suspensions, specifically within the Amazon ecosystem. You do get the free legal calls with the network of lawyers, but those are outside of Seller Basics. But the whole idea of Seller Basics for me was really just because I hate the account health industry. Like I didn't like the concept, like of just kind of like, people at their weakest moment and gouging them for thousands and thousands of dollars. And, this was a cool way to say, hey, let's build a system that's sort of like on your side. Like, hey, if you're paying us a monthly subscription, we don't want you to get suspended either. Like our economic interests are aligned. We prefer you not get suspended, but if you do, we'll do everything we can in our power to get you, within the Amazon ecosystem, get you reinstated. So, one of the questions I get asked a lot from resellers, it sort of goes around this concept of the authorized reseller conundrum that we deal with, where maybe you're getting threatening letters from a brand's attorney. There's a certain law firm I think we all know likes to do this and threaten us. And just understanding a couple things. One, the first sale doctrine, it has limited applicability to what we do, unfortunately. Or at least there's not enough clarity to say it goes further. So if I own this pen, I have the absolute right to resell it. Nobody's saying I don't. And the first sale doctrine protects my right to sell this pen, right?
Yeah.
But do I have the right to sell this pen as a new item on Amazon? And that's where it gets tricky, right? Nobody would say I couldn't sell this as like a used like new. But what the brands do is they pile on this warranty and they pile on this, concept of quality control, which unfortunately courts have recognized in some cases as being legitimate. Otterbox was a case where Otterbox won and defeated a seller's claim that they had a right to resell the first sale doctrine. So the problem is like when you sell it as new, that's where the first sale doctrine starts to weaken, right? Because you're making representations that new means it comes with a warranty, and there certainly are other arguments around this, but do understand that the first sale doctrine is not like it's not lock stock like the ultimate protection. You're not. It is not a guarantee that you won't get sued or that you don't have that you have a defense of getting sued. Okay. The first sale doctrine is very murky. Okay. It could certainly use some clarification. My fear would be that the clarification would be worse, not better, if the courts did. The idea, though, is that, yes, you always have the right to sell. So nobody's bothering you for selling used like new. Of course, you wouldn't make any money if you could sell used like new. Now, Amazon does kind of say, from our perspective, we don't believe in this other stuff about the warranty and the authorized dealers. We believe in the first sale doctrine wholeheartedly. They sort of say that. And what that means is if you're using Amazon's platforms, like intellectual property tools. They file these counterfeit without a test by, counterfeit with a test by. If any of this is done for the purposes of controlling distribution, controlling who's authorized to sell, enforcing a minimum advertised pricing policy, that is a violation of Amazon policy, right? So if Amazon finds out that's what they're doing, like they're not really reporting counterfeit, but they're just trying to enforce a MAP policy or authorized dealer network, Amazon has taken action. We've pushed Amazon to do this against brands for doing that. It's what they call brand registry abuse. So Amazon sort of plays in this sort of gray area where they too kind of like act like the first sale doctrine is bigger than it is. But yet at the same time, they say if it doesn't come with a warranty, it shouldn't be sold as new. But they kind of, it's kind of like they're just stuck between a hard rock and a hard place. And fortunately for resellers, they're more on the side of resellers because Amazon loves resellers, right? People don't understand that resellers, you break MAP pricing. So that's really good for Prime members, right? Prime members love cheap stuff. So if you're getting stuff way below MAP, Amazon loves that. That makes Prime members feel like they're getting value out of their membership. So that's what Amazon really wants. But then you've got these brands. So while the brands aren't really supposed to be using the brand registry tools for that purpose, sometimes they do. But do understand that, a brand can sue, and brands have sued. Now, statistically, the number of letters I've seen relative to the percentage of times brands have actually sued it's very low, right? I doubt it's even 1%, right?
Oh, wow. Okay.
It's not often, right? That the law firms that send these letters relative. The problem is we just don't know which brand.
Which one?
Right, because it's not the law firm, right? People will be like, "It's the law firm." Do they when they send those letters? Do they typically sue? It's like, well, it's not really the law firm's decision; it's the brand's decision to go forward. And we can't predict what the brand is going to do or not going to do. We can look at past history. So, like in the case of OtterBox, we can say OtterBox, we know for a fact has sued and they've won. But you just kind of have to understand, these little nuances in what we're doing. We are treading a gray line. It works, but there's risk. There's inherent risk in what we do. And that's why when you get those letters, we always kind of tell you, like, look, if you have absolutely zero risk tolerance in life, you probably should stop, even if you got a letter. Like if you can't sleep at night because of this, but you have to kind of be ready for this. I always suggest have a rainy day fund if you do get sued. Typically, we're going to try to just get you out of that litigation as soon as possible. And this brings me to like kind of as quickly as possible and as cheaply as possible. If and hopefully you can, right? Hopefully they're not going to try to make an example because, some brands may just want to go take you to court so they can have a win, right? And they figure you're not going to lawyer up. It's very expensive to go to court. So this is the other point I want to make too, is that do understand that when you go online and you do your legal research, whether it's with ChatGPT or Google, and you find these arguments, and people love to call me up and have chats about this argument that they read about and this argument they read about. I said, that's all well and good, but do you know how much it costs to litigate a case like that? You're talking 6-7 figures, right? Nobody's going to do that. You're not going to do that, right? This is how much litigation costs in America. There is no justice in our justice system. Maybe that should be the first lesson you have to understand as a small business owner. Like the courts are not for you. The courts are not for us. Okay. Whether it's getting sued by a brand or whether it's you get screwed by your supplier or your 3PL screws you and they owe you 10 grand or they did 10 grand worth of damage. Like you're not going to have the idea that the courts are really there for you is complete nonsense. And you have to accept that and you should do business accordingly. You should engage in contracts based on not just the idea that like the contract is, quote unquote bulletproof. Like I always tell my clients, I can design a bulletproof contract. And if they accept it, it's bulletproof. The problem is it's still going to cost you a ton of money to enforce it, right? It's going to cost an obscene amount of money to go to court. So you really need to do business on the presumption that you don't have a remedy outside of just, what you're dealing with now.
Yeah, that's a great point because I'm thinking about it. Like as a reseller myself, like let's just use Nike, for example, right? Like,
sure.
I'm sure they have this quote unquote bulletproof contract that Foot Locker or Dick's Sporting Good or whatever are not allowed to resell, but they can't enforce it because it's going to cost them money as well. So that's a really good point.
Yeah, it's brutal. But the thing is, those guys can enforce it. Those guys have money. When when I was at Microsoft, like nobody thought twice about going to court, right? Spending 100 grand, 200 grand, $1 million on litigation, usually just a drop in the bucket for those companies, right? Huge companies can
Yeah.
spend money, but for us as sellers, like anything we do that involves a contract, it's almost like the same theory as what we say to our sellers who do business in China, which is the vast majority, right? Like if you have a contract with your manufacturer in China, do understand that that's probably not something you're going to be able to enforce anywhere, right? Like it's a matter of trust, right? Is it good to have a contract with your supplier in China? Sure, it helps outline the nature of your relationship. You can kind of test the honor system of the other party if they're following the spirit of the contract. But at the end of the day, if your factory in China breaches your contract, you're out of luck, right? In almost any circumstance, you're not going to be going to China and getting enforcement remedies. It's just not going to happen. So,
Okay.
rant over. But those are things you do have to understand, because it's important to know that, because when you do business as a small business, whether it's Amazon, e-commerce, or whether it's local, like anything you do, it's like you do need to understand that like your remedies are limited, right? We aren't going to court. Courts aren't for us in most instances. And so you need to really, it forces you to do more due diligence on who you do business with, right? If you enter into a partnership with somebody, like you and your buddy want to start a new business, like do realize, like if you guys have a really bad falling out, it could be ugly, and it could be very hard to unwind that. And it could be very difficult because it's just the cost of dealing with it. It could be more than it's worth. And you may feel like this person did all the bad things and, should be kicked out of the company. But at the end of the day, it's like, that's a major litigation. So I don't know. Those are some lessons in life, I guess, I suppose, that, economics should always be the front runner of the decision, I suppose, is really what the underlying message is. It's like economics, the way I practice law with my clients is economics always should lead the decision-making process, not about who's right or wrong. Right or wrong is for law school, right?
Okay.
That's not really for how we do business. We look at the economics first. Is it going to cost you more money? Is the juice worth the squeeze, as they say? That's what we're looking at.
All right. Yeah, I mean it's a really really good advice that anyone can just have a good takeaway from that. And since we're kind of the topic of like reselling here and stuff, like I know there's not one thing that can make them feel safe, but let's say they're buying authentic products, right, from like a Walmart or something, and they keep track of receipts or email orders, credit card statements. What other things should they be doing to kind of help them feel safer, because it's really getting scary out there, getting your account shut down like a Section 3, even though you have all these things?
Right. So that's a really good point too. And actually, another point I should bring up is sourcing is so key right now. And actually, to a degree, I prefer receipts from Walmart over some of these suppliers I'm seeing out there. Right. People are
Are
going
you referring to like
these
wholesale or stuff like
wholesale,
that?
certain wholesale suppliers, right, that just have a catchy name, or they have Amazon is super particular about who you source from right now. If you cannot establish credibility of your supplier, it's bad for you. Amazon's going to assume they're dodgy. They just do, right?
Yeah.
Amazon's got two concerns right now: not just that the goods are authentic, but also that the goods weren't stolen, right? So they've got two problems to deal with. And as we saw in the case of a major case in California a couple of years ago, the stolen goods thing is real, right? There are people out there representing themselves as credible wholesalers who are dealing in stolen goods. I just dealt with another case a couple of weeks ago on this. Very credible company was selling stolen goods. You need to be your sourcing, and this is the problem. Your sourcing needs to be airtight, because you don't get a second chance. If your backup to, if Amazon's checking your authenticity, or you're defending a counterfeit complaint, counterfeit without a test buy, and your invoices are from like the Brooklyn basement wholesale distribution company, you're going to be out of luck. Amazon's probably going to shut down your account. I get that everybody's trying to chase chase margins, and I think Joy has a saying, I'm butchering it, but it's like, the margins on a suspended or shut down account is zero, right?
Yeah.
There are none.
Yeah.
So like you just, we get that the game is harder now. We get that everybody's looking for a little bit of edge, just like they're seeking alpha in the Amazon space. But you're taking just a ton of risk when you work with suppliers that have no reputation. I like suppliers that are like super famous, like was it Kiki, US Food, like suppliers. Yeah, like ones where it's like this company, I can Google this company and read about them. They're publicly traded. That's the best, right? If you're on the stock market, that's the best, right? Because then it's like, well, look, they're audited by the SEC. They're subject to SEC, not by the SEC, but they're subject to SEC mandatory audit, which is usually done by a credible CPA firm, which audits more than just their numbers. It audits their controls, their sourcing, everything gets audited. That's so much easier to defend than random cosmetics.com, who claims they've been around for 20 years and claims that they're Amazon compliant. And the problem is, even if they tell you they're Amazon compliant, when your account gets shut down, like there's nothing you can do about it, right? Like they don't care, right? They've already sold you the stuff. So they're long gone, not caring. Amazon's not likely to reinstate you because Amazon's looking for serious sellers, right? The game has changed. Amazon wants serious people who are going to take these core things seriously, that are going to respect their platform and do everything in their power to prevent the presence of stolen or inauthentic goods, right? And if your behavior, conduct, whatever, sort of leans towards you're entering to the sort of reckless disregard, willful blindness, they don't want you on the platform. That's just how it goes at the end of the day. So it's a really tough time to be a reseller. We understand that. Where you find your sourcing, these days, where you find that edge. And that sort of goes back to your original point. Like sometimes the Walmart receipt is just the best thing ever because it's like, that's so easy, right?
Yeah.
Amazon's cool with it. They always say things like, you need an authorized distribution agreement. That's not true. That's never been true. If that were true, there would be no retail arbitrage, right? Amazon, those Walmart receipts are great. TJ Maxx receipts can be good. The problem is you have to be able to prove the product you bought is the product on the receipt. So it takes a lot of documentation. That's getting harder and harder these days. But that's kind of the world we're in right now. It's just, a lot of these companies out there offering wholesale supply services just aren't suitable for Amazon. Maybe eBay, but not Amazon.
Yeah, just got to be careful out there. And that should be like a given already. Like do your due diligence, right? Like, researching their address, for example. If it's like a random house in like upstate New York, I mean, that's your answer right there. Or you just type into like one of these like scam advisor websites. If you see a bunch of, terrible reviews, I mean, stay away already,
If you're on Telegram, that's a for sure no.
Yeah.
If it's on Telegram. Don't split invoices with your friends. But yeah, if it's on Telegram, but it needs to be super credible. You need to be able to like say, okay, here's an article about the founder and his company being bought out by private equity for $200 million. That's a great article, right? Like something to say, look, we think these guys are clearly on the up and up. Like these are well established, and unfortunately, that's hard to do these days because a lot of these people have no reputation whatsoever. So it's hard. Yeah. But that's what Amazon's looking for, and if you get hit with inauthentic. That's a tough one to overcome. If Amazon doesn't like your documentation, it's pretty possible. So that's the state of Amazon at the moment on that one.
Cool. So kind of just transition from wholesale arbitrage into more like the private label. Can you explain their struggles of like knowing what a trademark is, a copyright, or even a patent? Just kind of keep it in simple terms to
sure.
Why are they important and how can they, protect like your own business or brand?
Right. So if I hold up my phone, what do you see? You see that?
Yeah, a brand new iPhone 17 Max.
That is true. But what is there? What do you see? What's the little gray thing in the middle? Maybe it's not that visible.
Oh, the logo. Yeah, the Apple logo.
Right. So what does that tell you?
It's an Apple product. They own it.
Exactly. What does it tell you? It tells you where it came from. Mm-hmm. Trademark is at its core a matter of origin, right? It's about the consumer being able to comprehend where the product comes from, right? Trademark is at its core, its origin. It's about, because of this trademark that I've put on my product, it's from me, not from somebody else, right? We see that with private label all the time. So trademark is really about designation of origin. It is also known as your branding, right? So this can be strategic. It can be used to kind of help you stand out, maybe some cute branding. But at the end of the day, it's a word, it's a logo, whatever it is, it's something that is a way to show the public that this is from you and nobody else, right? That's all a trademark is. Now, trademarks are super important because in the Amazon space, like your whole business revolves around your trademark, right? So you establish a company called Apple Computers, right? So the first thing you need to do is you need to go online and you need to register your brand with the trademark office, right? Now, in the United States, you can start establishing trademark rights simply by selling a product, right? Simply by bringing the product to market. You can say, right? So if I was selling, in 1968, if I was selling phones with Apple logos on it, I could claim I have prior rights to Apple, right? I was first. I was selling products that had the Apple logo, right? Even if I never registered it with the trademark office, I can say I have what's called common law rights to that brand, right? That I started it. And as long as I continue to keep selling it, those rights would continue in perpetuity. When you register the trademark, you're sort of you're putting everybody on notice. So that's sort of the official, okay, now my trademark is on file. And for purposes of Amazon, that's important because Amazon will not enforce a trademark unless it's registered with the trademark office. Now, again, could you go to court without a trademark that's registered? You actually could. People have done it. The damages thresholds are lower, but again, we're not really going to court on any of this stuff, so we don't have to worry about that. But in America and in a lot of the common law countries, unlike Europe, it's about first to use the trademark in commerce, not first to file with the trademark office. In Europe, however, and this does happen, people register their brands in the US and then they find their trademark being used in Europe and they're like, I lost out on my trademark. So it's always important if you're thinking about expanding to Europe to go and start securing those trademarks overseas as well. But that trademark is the core essence of your brand, right? This is all the goodwill. And the way it works on Amazon, and if you think about it, is a trademark by law encapsulates the goodwill of a company. Goodwill of a company is effectively, book value. You have the book value of a company and you have the market value of the company. What's the company actually worth, right? Maybe it's a multiple of earnings, right? That delta is your goodwill, right? That's that sort of intangible something that your company has that it generates wealth for its owners, its relationship to the consumer. All that's encapsulated in goodwill, right? And goodwill is considered inseparable from the trademark itself, from the brand. So when you sell your Amazon business, and we've done about $1 billion in e-commerce sales as attorneys for our clients, so we've done this a lot. As I was saying earlier, the most valuable asset you will sell is your trademark and the corresponding goodwill. That will likely be 90+% of your Amazon business, with the remaining percentage being probably just whatever inventory you have on hand, right? Being the majority of it, and that pretty much being it. So, so go ahead.
Yeah, I was going to say, so that definitely works with private label. Have you worked with businesses, let's say a wholesale business, they've worked with, suppliers for years and years, and their trademark is their, XYZ wholesale name. Have you seen something like that work for trademark, or is it just strictly for private label?
No, anything can be. I mean, if that's your branding, if that's who you are, the problem we saw, and I think you remember this with the bundling, right? And we were very against this because it was very much a violation of Amazon policies. That people were taking products that were like, Haribo gummy bears and bundling it with take 6 different flavors of Haribo gummy bears, and they'd call it Paul's Wholesale Collections,
Oh, wow.
or Paul's Collectibles. And they would create this brand on Amazon so that they could have what they were doing is trying to create private listings, right? That nobody, and some of these people even had the nerve, because people would get confused. They would see the listing and they would assume that's Haribo, and they didn't realize it was just somebody creating their own private branding on Amazon to sell Haribo. And then they would get that company would actually have the nerve to file IP complaints, and a lot of people lost their accounts over this. So we warned people to stop doing this. That this kind of creeps into the territory of like a pass off, where you're sort of like putting your own brand over somebody else's branding, which you're not allowed to do. I can't take this phone and put Paul phone, the P phone or whatever on top of it and start selling it and passing it off as my phone. It's Apple's phone, right? That's also illegal. So. Wholesale companies can have branding. I mean, any business engaging commerce can have branding in whatever categories they're operating in. It's just what's the use of it, right? Why are we doing this? So, could a retail arbitrager have a brand? Absolutely. Why would they need it? I don't know. It doesn't really make a whole lot of sense. There was a time, like I said, with the bundling, that was the thing. Now, with the trademarks, and one other thing people do mess up is a lot of people that get their trademark, they go with Amazon. So you need this trademark register, the trademark office, to get access to Amazon's brand registry tools, right? So that's the ability to take down listings that could be infringing on your trademark. Basically maybe using a name too close to your name or actually infringing on your brand. It also is the right to use the A+ content, so to make those more better looking listings, right? You need a branding. You need a registered trademark to get that brand registry. Now, Amazon will typically give you that brand registry A+ content access right away. So even if your trademark hasn't been approved, it's just applied for, you have what's called a serial number, Amazon will start unlocking the A+ content right away. You will not be able to go and start enforcing that trademark against other people, however, until it's registered. Amazon will not let you do. Amazon won't let you do it. You can do it outside of Amazon, but Amazon itself will not let you do that.
Okay, that makes sense. So considering that, like, when should new sellers get a trademark? Should they do it like before they start a company, or when they're actually start to make sales and stuff like that? Like, all right, it's worth now getting a trademark. We can spend more money on it and stuff like that.
So if you're creating a product at Amazon, you're a private label seller, and you want to start a brand, I think the first thing you do, even before you know if you need an LLC, I think to some degree, I mean, you can do both, but is to figure out if you want a trademark, because is to figure out your branding, right? Like, you shouldn't really be going to market. I know in the 2015, 2016 days, you could literally just like do generic listings, but
like an iPhone case or something.
Yeah, but those days are kind of over. Like, if you're bringing a product to market, you need to know what your branding is. I think it's important not only to do a trademark, to file a trademark, but to do the research, because here's the tragic story. Let's say you come out with a product and you put a brand on it, and maybe you've lived in a bubble your whole life. You never heard of Apple computers, and you put out the Apple something, and you get a lot of sales in the first week or two, and then all of a sudden, guess what? Turns out you're not getting that trademark, or the trademark gets refused by the trademark office. You got 1,000 reviews, great ranking. Unfortunately, you can't sell that product anymore because the underlying brand associated with that product is no longer valid. Can you just go and switch the brand? No, Amazon doesn't let you do that. They don't let you just change the brand from one brand to another. You can't be like, Amazon, oops, I know I called it Apple before. That was stupid. Now I'm going to call it Pear. A little GTA reference for those who are. I'm going to call it the Pear phone. You can't just change it. You have to start over again. So, imagine somebody going to China, ordering $10,000, $15,000 worth of inventory with a particular branding on it, and then only to find out a few months later that that's all unsellable inventory on Amazon because the branding is wrong. So I think the mistake people often make is one, they don't do the research enough. They think all they do is they look on the USPTO website and think, okay, that's it, I'm good. A lot of times those searches aren't. The USPTO is not Google. It's not as easy to search as you think it is. Things get missed all the time. Secondly, there's a lot out there that may not be registered, right? There are a lot of brands that have marks that they never go and register, and those could interfere with you one day. You could get a nasty letter from a major company saying, hey, we actually sell a product with that same name. We just never registered it. So cease and desist with that trademark, or we're going to, cancel your mark for you. So stuff like that happens all the time. And it's a matter of, a couple $100 to do a more comprehensive worldwide search to see what's out there. Or you do the search and you get it, and then you realize that all your European and UK, and it's a problem over there, right? So your expansion options are limited as a private label seller. The other mistake I see sellers make, and this comes in more later on, is like they create a brand, on brand registry, and then that's it. They never think about branding again. They create multiple variations of products. Think about Kellogg's cereal. You've got Apple Jacks. You've got what's another? Fruit Loops. Okay. Imagine your top selling product, your brand registered brand name is Kellogg's, and your top selling products is Fruit Loops. Now imagine 3-4 years from now, you're about to sell your company for millions of dollars because mainly your Fruit Loops product is just so popular. And you find out that you don't have the right to the brand name Fruit Loops, right? That sub brand, right? Because you thought, I had Kellogg's, that's my brand name. I never thought to go and register for the trademark Fruit Loops. And then you find out, actually, no, Fruit Loops is taken. And therefore your brand is now worthless, right? That's tragic. And that has happened to people, right? And that's sad. So it's not just about registering that first trademark, but as you grow a brand, you don't necessarily have to do it right away, but you should do the research. If you are going to come up with variations in different products, product names, you should do the research into that branding too, because once you have a hit, it's really hard to change it, right?
Yeah.
So you want to just do all that registration. So that's trademark in a nutshell. The other two major types of IP are patent and copyright. Those are a lot easier to understand. So we can dig into that real quick.
Sure. Yeah, absolutely. Can I just go over the trademark before we get to copyright and patent? Like, how long is usually like the time it takes and the cost roughly?
So the cost of a trademark, it depends. Different law firms charge different amounts. If you're American, you can technically do it yourself. The fees are, I think, $300 in filing fees, I believe. Don't quote me on that. The timeline right now is roughly over a year, right? So you file the trademark application, you get a confirmation right away. This is a serial number. And you may hear nothing for like 9 months. And then you get what's called, basically saying notice of allowance, and that your trademark's going to get published in this online gazette that the trademark office publishes every month. And that gives people the opportunity to oppose it. So in case anyone's monitoring those and says, I don't like your trademark, I think it's too close to mine, they can oppose it. They have 30 days to file that opposition. So that all in, by the time you go, an uninterrupted trademark, by the time you go from filing that registration to actually getting the registration certificate, it's about a year, give or take. Now, if there's a problem with your trademark, usually within about 4 or 5 months, you'll get something called its office action. And this is a letter from the U.S. Trademark Office saying there's a problem with your trademark. And those problems could be likelihood of confusion, meaning your trademark is a little too much like this other trademark we found here in our database, right? Because of that, we are going to refuse your trademark registration. And then you have an opportunity to respond and say, it's not quite like that, and here's why. And a lot of times that happens. Like, a lot of times the trademark office wants you to do their job and just prove that, even if it's kind of obvious, like you did the pre-work, like they just want to see it in writing. They want you to do it. Another issue is it could be descriptive, right? So if I sell a product that is vitamin C, I can't call trademark vitamin C, right? Because I'm just describing what I'm selling, right? If I sell a supplement called vitamin C, it can't be vitamin C. It cannot be my brand name. It's too descriptive, right? And a lot of times people get into trouble with descriptive because they don't think of it as descriptive, but it can happen where the trademark office takes a position that something is too descriptive. So any number of issues can pop up. Disclaimer, like if you say my product is the world's greatest vitamin, you might have to disclaim the word vitamin, which just means you don't have the exclusive right to use the word vitamin. Now, nobody can come in and say the world's greatest vitamin, but at the same time, the word vitamin itself is so crucial to the category. Like, you can't just have it. You can't just own that word. Nobody can. So those are a number of issues. So usually within about 4 to 6 months, you'll get a sense of where you are on the path to approval.
Okay, and you're not just left out in the dark.
Hopefully not. If it is a year, usually that's a sign that you're probably going to be okay, right? You'll get in about 8 or 9 months, you'll get a notice of allowance telling you that you're on your way to registration, which is a good sign. The other thing to know too is that when you file for a trademark, you have 2 situations where you can file. You can file as I'm already using the trademark in commerce, okay? which means I'm already selling this product.
Selling it.
So I'm just registering it. Okay, that's and they'll say, when did you start using this product? At least as of what date? And you give them that date. The other scenario is, I'm planning to use this product, this brand name in the future. So that's called an intent to use trademark. Intent to use, you can file, if you get it, it's 6 months, and you can do extensions and basically drag it out to about 3 years. I think three and a half years or something. It's roughly 3 years. You can drag out the extension. So that gives you time to basically placehold a certain trademark. Doesn't mean you can go in and do what the trademark office is very concerned about, just so you understand, is the whole domain squatting thing. They don't want that happening to trademarks. So they're very, very cautious about people who just go in and file tons and tons of intent to use marks. But you can, if you have real intent to use a product in commerce, you haven't quite have it. It's not quite ready for the market, but you're it's in process. You can file what's called an intent to use trademark. You can get you get the approval, not the registration. And then once you have the product ready to go to market, you can submit the use. You say, I'm finally selling this in the market. You can submit that to the trademark office, and then I'll convert to registration. Now, typically, you can't get brand registry until you show use, because the brand registry also wants to see your product being sold with the branding on it. So
I see. Okay. So is that something that someone that wants to do an MVP just to see if it even sells before they move forward and invest more time and money to it?
Sorry, I didn't hear it.
Before they do the full trademark, if someone just wants to do an MVP, minimal viable products to sell,
yes,
before they full deep into it.
Yes. So trademark is important. I mean, I think it's two different things. I think is the product you're going to sell marketable, and you're going to go on Helium 10, you're going to go on whatever, Jungle Scouts, Data Dive, one of those products. You're going to use a service provider, maybe. You're going to figure out what the product's viable. I guess that's arguably step one, unless you already have a product in mind that you're just committed to, right? Once you find that product that you want to sell on Amazon, then you got to think about branding. What am I going to call this thing, right? How are people going to know? What are they going to know it by, right? Scrub Daddy, right? First, I think the guy probably came up with a name. I'm imagining the Scrub Daddy guy probably first figured out he wanted this sponge with holes in it to do whatever. And then, at once he kind of okay, I'm going, I'm doing it. Decided I want to come up with a name for it. Yeah, I'm going to call it the Scrub Daddy. So typically you want to know what you want to sell first, and then that's going to direct your branding, because, your branding may incorporate something, from what you're doing, right? Right. The Scrub Daddy obviously implies a scrubbing mechanism, right? Not, it's not a television. It'd be a weird name for television. So, yeah, I mean, I think first and foremost, you got to figure out what you want to sell, what the market is, what the opportunity is, all those things, that MVP. Then you want to figure out branding. Then you want to go to marketing. Okay, well, how do I bring this product to market? Now that I know I want to bring it to market, how do I bring it to market? What am I going to call it? I would say that. So I'd say trademark is probably step two. But what I would say is you want to know your trademark before you go to market, because you should do the due diligence on your trademark before you go to market. Because as I said, you could have a tremendous amount of success, and then all of a sudden find out you're not allowed to sell that product because you did the wrong branding.
Yeah, you're working backwards at that point.
Exactly.
So how does copyright and patent work, with all of this?
Okay, so patent is a totally different concept. So trademark is about origin. In patent, you're talking about exclusivity, the exclusive right to sell a product or use a method. And in patents, you typically break down into two categories. You've got your your design patents, which is the way something looks, right? So
like the iPhone, they have a patent on the way it looks.
The way it looks, right. So it's now design patents are known for getting, you can, if you put any effort into it, you can get around a design patent, right? Samsung, anyone can get around a design patent. You just have to make it look different, right? The standard of, when an ordinary person looking at the two products side by side conclude that these are the same, right? Mm-hmm. So design patents are easy to work around. Doesn't mean they're a bad idea. Design patents are great. A lot of times when people get copied, the copiers don't even bother to change the product or even check for a design patent. So it's never a bad idea to have a design patent. A utility patent is a little bit more complicated. A utility patent is sort of the novel invention, right? The novel function, right? So it could be a combination of ingredients in a supplement that causes a certain reaction in your body, right? It could be just a device that does a thing, right? So you think about inventors and what people inventing and creating things. That's more what we call the utility patent, right? So again, it's when you're doing an MVP, viable product analysis, you're going to probably want to think about patent before you think about trademarks, just to make sure, one, do you have a right to patent your product, and should you? Right. And two, does anybody else have a patent that could stop me from selling this? Right. Sometimes people, they go to the Canton Fair and they meet the supplier. They say, wow, I see this product. There's only one seller on helium. This guy's making a killing. I'm about to corner the market. Right. I'm going to corner the market because nobody else noticed this. Nobody else noticed that this particular avocado peeler is just crushing it. I'm about to cash in. There's a reason. There's usually a reason. And unfortunately, people learn that the hard way. So it's important to do, some patent analysis. Sometimes it's hard to do. Sometimes it's more expensive than just learning the hard way too, believe it or not. Because most of the time with patent, like usually unless you're doing big numbers, you're likely going to just be kicked off. Your product's just going to get kicked off of Amazon first and foremost, right? It's unlikely you'll get sued for infringement these days for Amazon. It's people just it's not worth it most of the time. Not to say it couldn't happen, because it has, but more often than not, Amazon even has its own internal methodology for dealing with patent infringement when it comes to utility patents. It's a special arbitration that you go into. So yeah, you do want to know. You want to know if the product has a patent, and you want to know potentially if you could patent it. Because the thing about patents too is you have a time limit, right? Once that product is sort of made available to the public, right? Once the public can kind of see what that product is, right? And there's a complex definition of what that entails, right? It doesn't necessarily mean when it's first sold. There's a clock ticking, and you have 1 year, right, to get that patent. This is known as the grace period. So if you don't apply for that patent within 1 year of it first being sort of commercially available to the public or shown to the public, you lose the right to patent that forever. It's gone. Okay. The other thing to know about patent too, and this is something I tell my clients all the time whenever they get hit with a patent infringement accusation, is look online, look on YouTube, look on Amazon, and see if you can find the exact same product you were selling being sold 1 year before the patent application date. Because if you can, you might have been able to establish that the prior art invalidates that patent. Meaning, if I was selling this AirPod product and Apple came and hit me up with a patent, and I said, okay, well, I'm going to go on YouTube and I see, oh, look, here's 30 videos of people reviewing a product just like this, or even Apple's version of the product, but it was more than 1 year from their patent application date. That tells me that there's a potential of what we call prior art, which can invalidate a patent. Because in other words, you can't patent what's already out there. You can't patent what's already been invented, right? You can't invent what's already been invented. So there is this sort of way to do that. We see that with design patents a lot too. There was a time on Amazon where people would go and file design patents just to screw with other people, even after the fact. But that's become a terrible idea. And then lastly, copyright. You're thinking about like original, works of, you're thinking about original works, right? Original creative works, artistic works, right? So the way copyright works is it can be in your photos, right? If I take a photo of the Eiffel Tower, right? I don't own the copyright on the Eiffel Tower, but that particular photo, that very specific photo I take, I instantly have copyright in that photo, right? So any photos you put on Amazon, though, and somebody comes around and copies your listing, you technically have a copyright claim. You can incorporate copyright into your product. Like I always tell my supplement clients, put cool artwork on their bottles, right? Because a lot of supplement sellers will play this game where they use these very boring bottles, right? They use very generic, boring-looking bottles, and then their competitors come in and use the same generic, boring-looking bottle, and the consumer's confused as to who they're buying from, and they just look for the cheaper price, and it happens all the time. And you can't copyright that bottle; it's too plain and generic. So what I always tell my clients is make the product look cool. Put like a dragon on it, right? If you're selling, ashwagandha or something that makes you feel powerful, put a dragon on it. Put something on there that if somebody copies it, you can actually have a cause of action to stop them, right? You need something. So copyright's useful in that respect. Copyright can protect your images. It can protect your writings. Obviously, any content you put out there can be, instruction manuals could be copyrighted. I've seen that happen before. Somebody ripped off our clients' instruction manuals. we worked on a case where a Halloween costume was copyrighted, and our client sued a bunch of people for infringing on their Halloween costume because the design of the costume was a copyright. There was original artwork that went into that. So copyright can be a very powerful tool. It is not easy to enforce copyright on Amazon. It's actually very difficult because when you report copyright on Amazon, it's called a Digital Millennium Copyright Act, DMCA takedown. The problem with the DMCA takedown is there's this thing called the DMCA counter notice, which anyone can file, saying, I don't think I'm infringing. What that does when you file that counter notice, it basically puts Amazon off the hook. So they no longer care about this. They no longer care about this complaint anymore. They'll just let the thing stay. They'll say, it's up to you. If somebody files a DMCA counter notice, you have 14 days to go to court and get a court order to quash that. Otherwise, we're going to let it back up on our platform. And we are statutorily immune from any liability as a result because we gave you the chance to take action in court. And again, what do we say? Court's very expensive. So copyright is useful if you have a wildly successful product. It's very cheap to incorporate. And if you have a wildly successful product to the point where you actually have the financial ammunition to go to court, it's a great tool to have. So from my perspective, I think it's always good to incorporate copyright as much as you can, incorporate artwork, incorporate creative, as much as you can to the product. It's a cheap thing to add. And if your product, is wildly successful, you'll be glad you did it. Worst case scenario, you wasted some time on some drawings. And do be mindful that when you hire somebody overseas to create this work, you sometimes need to get them to assign those works to you. You don't, it's a complicated body of law.
That's a really good point. Yeah, because they could end up having the copyright if you didn't do that. Like someone in Fiverr, for example.
Exactly. We see this with the M&A deals all the time. People forget to go get those things. Photographers, the people you hire to do your, if you hire photographers to do your listing, maybe that's not going to happen more with AI. The vast majority of photographers will always give you the right to use to use the photos, but not the right to transfer them, assign them. They own your photos. It's crazy. So if you're working with a photographer, make sure you own the photos. Like, make sure you negotiate that in your contract. That, like, these are my photos. If I sell my business, I can transfer them to the buyer. I don't need your permission, right? See that all the time. So it's
super important to kind of just like sum it up. I'm getting the feel here. It's like a carpenter. You want to measure twice or three times about everything before you cut.
Right. Absolutely.
Yeah. And to kind of just bring us to a close here, and again, Paul, thank you so much for your for your time here. I got two more questions here. With our conversation, with general e-commerce, especially with Amazon, where do you see where it's going in a few years? I know it's hard to tell, but just based from your experience and kind of just talking to different people, the future of private label, resellers, and just the platform in general, because things have changed a lot, especially this year and a half with, brands getting gated out of nowhere, all these Section 3s and stuff like that.
Yeah, the brand gating thing is tough. These brands are very powerful and influential. Apple was one of the first ones to do that back in 2018, 2019. I can't remember when they did it, but all these brands are seeing it. They're all claiming, woe is me, counterfeit. They're all kind of exaggerating what's happening to them and making, and stupid people in Congress believe them. And it's just, it's crazy. I think it's not great. I mean, I think it's not like we're all going to be out of a job. I mean, I think arbitrage lives on. Wholesale will live on. It'll be harder. But I always think there's going to be room for it. I think this goes back to my original thoughts. Maybe that's another conversation about, sellers should be lobbying Congress. If you want to see change in the right to resell things and the underlying economic fairness, it's good for the consumer, right? You need to talk to Congress, right? I've had clients who've been gated, who've had $1 million of inventory, $500,000. I will tell you this, just a little secret. I've had them call their congressperson. I've had them call their state politicians and had their state politicians reach out to Amazon. And that's how they've gotten through the process of getting re-ungated. Because it's just so unfair what Amazon did. Like, I bought all this inventory for Christmas. Overnight. Yeah, overnight. Yeah. It's like I bought $1 million of inventory leading into Q4 and you just gated me. So
I know a seller that happened to a seller.
It happens to many. I know many it's happened to. And every time I tell them, I said, talk to your congressman. Get somebody from your congressman's office or your state senate or your state, whatever, assembly, get them to write a letter to Amazon government relations on your behalf, right? Tell them what to write. This is what happened, and demand an explanation. You're destroying a small business in my town. You're destroying my constituent's business. Get them to answer for that. A lot of times that turns out well. So if you have a politicians willing to do that, but I mean, this is where I feel like, the future could be brighter if we as sellers took more action as a unified front, which I've tried to do years ago with the Online Merchants Guild. It's a whole other story. But I still think that's the way to forward. I think it's tough. I think being a private label seller, pressure's on, competition's on. It's never been harder to be a private label seller. Hopefully tariffs will go away. I do think the court's going to rule against the current tariff regime, which will take some pressure off. But at the end of the day, it's tougher and tougher. So yeah, patents more than anything. Patents, I think, looking for products where you can get a patent is key, because you got to have an edge, because these days it's literally a split second. Once your product hits the market, it's literally a split second. You'll have 30 imitators overseas, and they play by different rules overseas. Unfortunately, I always say sellers in China, the sellers in China don't ever sell their own brand. Right. I've seen sellers in China, they'll have 4 sellers selling a particular brand. And none of them are the actual, the actual brand owner is nowhere to be found. Yeah. And one of those sellers will sell through Woot, and that's where the hidden inserts are in the Woot inventory. Yeah. And then the Woot account gets suspended for it's the games that are being played. It's phenomenal.
It's pretty crazy, and it's not just in e-commerce as well. Have you heard of Mr. Beast, or you know about him?
Yeah, of course. Yeah.
Yeah. So there's this Russian guy that is doing the same stunts as he's doing, like word for word script, but just in Russian. Yeah. It's just crazy, So yeah, overseas just can't do much about it.
Comrade Beast. I don't know. Or whatever.
Oh yeah, that's his name. I didn't even know about it.
No, I'm just guessing. I'm just like, yeah. No, I mean, totally. And that's, again, it comes down to, we are small businesses. We are very powerless and we don't know how to use we have so much power. As a collective, we all vote. The funny thing is, you think the corporations have the money. Right? I used to be a lobbyist. I was on Walmart. I did a lot of lobbying. The corporations have a lot of the power, have the money, but it's collectively we have money too, and collectively we all vote, right? Small business owners actually vote. So in a way, we have the potential to be more powerful, but it's just getting small businesses to work together is so hard. Yeah, it's just, and it's frustrating, because if you want to change the future, if you want to change the destiny, if you want to restore the balance of power, it's not going to be through Amazon antitrust litigation. That's nonsense. They're not doing anything. It's going to be through us, collectively building a lobbying, political front that represents the small sellers and against big Amazon, and that's how you push change through and protect our livelihood. Until then, overseas sellers are going to have an incentive to cheat. We can't cheat. We live here. We face American consequences. Nobody in China is going to get in trouble for cheating in America. I mean, that's crazy, right? Yeah. I feel like if anyone actually understood that politically, they would do something about it. But who's delivering that message in the right way? Who's knocking on Congress's doorstep every day, telling them the stories about how this is happening day in, day out, day in, day out? Nobody. Because if they were, I have a feeling, especially in this regime, things would change. Things would change a lot. But it's just, here we are. So that's my big picture message, is I don't think it's going to get harder. It's always going to get harder. Every year it gets harder. Fees go up. Amazon makes it difficult. They keep moving the goalposts. It's just going to keep happening. There will still be an Amazon. It's going to be less lucrative for newcomers. I've seen a lot of people, a lot of resellers have been in the game for a long, long time. You're talking 2012 getting out of the game. So it is getting tougher. I think and maybe to some degree that's good. You want to thin the herd a little bit, but at the end of the day, I do think it could be a lot better if we work together as a collective. But that's just my soapbox I'm going to get off right now. So.
And one last thing to Andy here. What can they do to legally protect, their business, so that way it can help them, sleep at night a bit better, whether that's, maybe using your service like Seller Basics, or just, maybe reaching out to you directly?
Yeah, so you can email me, paul@ecom.law, ecom.law. But Seller Basics is great too. Sellerbasics.com is a great program because you're paying a monthly subscription fee. Something happens with your Amazon account or ASIN, we're helping you get reinstated. We're working the Amazon process. We know the Amazon people if it needs to go that route. But the other thing that people don't really seem to value seller basics is those free legal phone calls. So calls with me and my other lawyers and lawyers outside and other firms that I have a network with, right? Depending on what the issue is, we have it for you. And I could tell you that the vast majority of my clients who've had massive issues in their lives, right? Massive legal issues, major problems. So many of those issues could have been avoided with that 15-minute phone call, which is why we offer it. Because it's like, I want people to just like run it by a lawyer. It's like the Geico commercial, like 15 minutes could save your business. 15 minutes with one of our lawyers could save your business. I mean, that's peace of mind, for the price of seller basics. Yeah, I think people should join and just have that lawyer. You can run it by, nobody minds. There's unlimited calls, like you can, whatever you need, but it's just like, you could really, people make a lot of stupid mistakes and don't even realize it. And if you think ChatGPT is going to save you, I promise you, it's just not there yet. I've used it. There are better ones out there, but none of them are good, right?
Yeah.
Like you're still doing, it's almost just as much work because you have to proof and reread everything it says. What I like about those things is just sometimes it's just nice to like have something clean up your writing. Like you can just kind of write sloppy, get your mind, you do the brain dump of what you want to say, and it can
like
just
fix
help
the grammar and all that.
Yeah, just help you organize it, and it just kind of moves that process along faster. But in terms of like, I don't know, even passing the bar, I don't even know even if it could pass the bar, I don't know what the bar exam has to do with price of tea in China, because like the bar exam is so far divorced from what we do as lawyers in this world that I can't remember the last time I had to deal with a trespassing case, but I'm sure it was on the bar exam. Yeah. So like, don't believe the hype. Like we're not there yet. People send me so much more ChatGPT stuff now when they want to set up, and it's like, it's not helpful. One day, like I'm definitely like on a 5-year time horizon, probably before this stuff ends the transaction. We're all going to have to be courtroom lawyers, but not today. Right. So I'm not saying I don't see the future and the writing on the wall here. I'm just saying it's not today. So,
yeah. Cool. All right, Paul, again, thank you so much for your time. And,
thank you.
We'll see you later.
All right. Take care. Appreciate you.